Some Maori opposed to asset sales have staked their claim over the issue of water rights at the Waitangi Tribunal. But how Maori define ownership versus the Crown's definition could prove to be a point of contention. So to explain more, we've got Professor Rawiri Taonui from AUT joining us. Morena Rawiri, I've got to say, yesterday we had Manu Paul on. He said that Maori own the water. The Prime Minister on breakfast said yesterday that Maori don't own the water, but they have rights to it. And the general population says that we all own the water. So what's your thoughts on the situation?
Well, in Pākehā law, LAW, philosophically no one owns the water, but governments exercise a sovereign right and authority akin to ownership in terms of the management and of resources, natural resources such as water. In the Maori world, you could say that the water is believed to belong to Papatua, Nuku, the Earth Mother and other deities, but that tribes exercise a sovereign authority or mana over fresh water, and it's akin to an ownership. Now, where there's a tension is that when New Zealand was colonised, Māori rights to water were recognised under the phrase Aboriginal or customary or native title, and being basically the full, exclusive and undisturbed ownership of taonga and lands, forests, fisheries and estates and so on and so forth. Now, over time, the Crown has accrued the authority to manage the water, and the key issue here is how did that transfer take place? I mean, if the Crown purchased those rights from Māori after the treaty was signed, then that would be fair and legitimate. However, if the Crown just assumed control and authority over water rights without, in an unfair or unjust way, then we've got a bit of an issue. There needs to be a debate and probably a resolution at some stage.
Right, so is this going to be done by the Waitangi Tribunal, or they were talking as well yesterday about maybe taking it onto the High Court if the Tribunal doesn't have enough weight?
Well, the Tribunal will produce a report, and probably quite quickly. I think that's really important because internationally there's been a lot of debate about Indigenous rights over freshwater resources for about 2 decades or so now. And what we lack in New Zealand is a seminal statement that brings together common law principles, a Pākehā view, a Maori view, reference to a number of declarations, covenants and conventions in international law, and also 2 or 3 precedents in similar cases elsewhere in the world over the last 2 years. Now, from that point, the Maori Council could say, go to government and say, listen, here's a report, what are we going to do about it? If the Crown doesn't want to play ball, then the Maori Council could seek an injunction against the sale of state-owned assets in the High Court. On the other hand, the Crown might choose to go the way of the foreshore and seabed and pass legislation outlining the rights or limiting them or delineating them in some way. And a third option might be the Crown talking to tribal leaders and coming up with some form of settlement or accommodation that would suit them both. We've already seen in the last week that Bill English indicated the Crown might be open to giving preferential shares in state-owned assets that are just about to be sold. And John Key said, well, no, we're not going to do that, but we might buy back some shares and try and settle it that way.
All right. Thank you for joining us this morning. AUT's Adjunct Professor Rawiri Taonui.
Thank you.